think yesterday the Ministry of Information came out with some release. But before I go that, Sam, you made a very good distinction between cultural practices and customary law.
Okay.
Now, if you look at Article 26, it gives the right to practice your culture. But then it is one of the articles that has a caveat, which is that the customary practices which are dehumanizing or injurious to our physical. So just to bring it out that absolute statement that culture is part of our laws is not necessarily right. There is a caveat, and people should not, close their eye to that particular caveat. Now, on the issue of what the step the government is taking, and it's in sync with the welfare principle that is established under Section 12 of Act 560. Indeed, when the whole incident was reported and the euphoria, there was an interministerial committee that was set up, made up of the Ministry of Interior, the Chieftaincy Ministry, the Gender Ministry, and of course the Office of the Attorney General and Ministry of Justice was there to give the necessary advice. We believed, and this is what we acted on, that in the midst of all the euphoria, it was the best interest of the child that was important. Right. In as much as people were agitating for prosecution, I think the focus was too much on the offense that had been allegedly committed than on the interest and welfare of the child. And so in accordance with what we believe should be the priority, which is the child, the Ministry of Gender and of course the Ghana Police Service immediately took the child and the relative to a place of safety. As the press release from the Ministry of Information indicated, the child is currently doing well, going through the necessary social welfare recommended protocols. There are two caregivers. There's a medical doctor that are taking the child through the necessary protocols. There's a case worker on standby to ensure that all the protocols regarding the welfare of the child and the best interest of the child are clearly adhered to. Of course, concurrently, then police are also doing their investigation. And that's what the statement indicated, that the Ghana Police Service has taken statements from the Wolomo. They've also taken statements from the parents of the child. And so my admonition to all of us is, I think there was too much concentration on the crime itself. It is good. As I've indicated, I have been happy about the sense of alertness of Ghanaians and the general public on human rights and children's rights. But I think we should equally bring to the fore a discussion on the best interest of the children. And the Office of the AG is consistently in touch with the Gender Ministry to ensure that the interest of the children is done. So there are currently medical issues that she's going through, psychological treatment that she's going through, and of course all the determination and assessment of the age, etc. are going through. We are on top of this matter, I can assure you, and hopefully next week I think we should be making some progress beyond what we've already.
Now, it is a fact that she's not 12. What we are not too sure about is whether she's 16 or will turn 16 in July. Is that a central part of what your instructions are to the investigators?
Sam, my position is that whether 12, 15 or 16, the law is clear if you look at Section 14. And I've heard discussion. And for me, again, I keep saying that this event is a good opportunity for us as Ghanaians to resensitize ourselves. It is neither here or there whether 12, whether 15 or 16. Of course, I'm mindful of Section 122 of Act 560 on the determination of the age of a child. It is key only for purposes of ensuring that Section 14 has not been breached. And clearly, the arguments that are being thrown out there, whether 12, 15 or 16, still does not meet the age criteria. So if there's any determination of ages as to 18, so that 12, 15, 16, I think is neither here or there. Betrothal marriage, again, respectfully, I have to disagree with my learned, respected senior. It's also neither here or there. I think the Section 14 is clear. And even Section 1, it defines a child within the context of Act 560. It's 18, so whether 12, 15 or 16, and if we are invoking Section 14, why are we discussing even 12, 15 or 16? But of course, as part of the prosecutorial processes on evidence, it is important to determine the age only for purpose of ensuring that the child is 18 or not. But 12, 15 or 16, I'm afraid still doesn't cut it.
is immaterial.
It's immaterial, yes.
And please give the education back to our audience in a summary. The age is immaterial now for as long as she's not 18 because what?
Because Section 1 and 14 of Act 560, first of all, Section 1 defines a child to be someone who is 18 and above. I mean, who is below 18.
Right.
If you go again to the Section 14, and so I've heard also the arguments that when people look at Section 14 and say that the age of marriage is 18 and say, well, betrothal is not 18. I said, look, you forget, the opening sentence is that no one shall force a child. Mm-hmm. And that determinative interpretation is in Section 1. Mm-hmm. Again, the purpose of Section 2 is only to emphasize the marriage, but it still does not take away. If you are telling me then betrothal is not 18, then what is the age for betrothal? It's not stated, and it's covered under Section 1.
So the emphasis is that you concur with Mercy Labi that below 18, there cannot be betrothal or marriage.
Absolutely
just as
right.
Angela has also emphasized.
Absolutely right.
It cannot happen at all.
It is immaterial. Look at Section 14 carefully. And I always like to say you have to give a purposive interpretation to Act 560. It starts off with Section 1 on who a child is. And the purpose of the Act, if you read the long head, is to protect children, in summary. And so if you are looking at a particular provision that emphasizes that marriage ought to be 18, to say that, well, then betrothal need not be 18, I'm afraid I do not agree with you. Because Section 1 and 14, you have to look at it purposively.
I don't know if I'll put you in an invidious position if I ask you this question, but I must still ask it. In that circumstance, a crime has still occurred.
If proven, if the facts are proven, and it's critical to prove this fact, the age is key. But I've indicated that the age is key not because people are peddling around that she's 12, 15, or 16. The age is key being 18.
The Gadangbe statements, the Mankralo's confirmations, the press conference they all hold, confirm she's not 18. They confirm that she's been betrothed to, some say to the priest, some say to the spirit that the priest serves. So, offense has occasioned, correct?
You know, by my profession, I tend to be slow in stating definitely because the police are still conducting their investigation. Even though we may have read on the news outlets, I believe that we must hasten slowly by allowing the police to go through and give us the docket with all the evidences. And on the issue of marriage to spirit or dating, Ghana has a very broad human rights framework. And I like to tell people that even if you look at Clause 5 of our Article 33, it is it's so encompassing. It says that the rights, declarations, and duties that have been mentioned in Chapter 5 does not exclude those that have not been specified.
They are inexhaustive.
Exactly, they are inexhaustive. And if you look at the true intendment of Act 560, there is that understanding. So even if you talk about spiritual marriage, the issue is the welfare principle. Whatever has happened, can we rightfully, reasonably say that it augurs well for the welfare or the best interest of the children?
The very reason I qualified my question to her